Welcome to Do It for the Case Law for Tuesday, August 25th, 2026. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Today we are covering 68 federal appellate decisions across 5 reporter beats. Do It for the Case Law is a news reporting service. We summarize and discuss federal appellate opinions. Nothing in this broadcast constitutes legal advice. Let's turn to James covering criminal justice.
Thanks, David. 18 cases for criminal justice today. The disposition roll-up: 14 affirmed, 2 dismissed, 1 reversed and remanded, 1 vacated and remanded, and 1 split outcome. We start with the reversals and splits before moving to the affirmances. In the 10th Circuit, the court vacated Mark Phillips's first-degree murder conviction and remanded for a new trial because the district court committed plain error by failing to instruct the jury that the government must disprove imperfect self-defense beyond a reasonable doubt. The judge's instructions effectively limited the defense to involuntary manslaughter, which could only be considered after finding the defendant not guilty of first-degree murder, affecting Phillips' substantial rights. Also in the 10th Circuit, the court affirmed Coker Barker's murder and firearm convictions, holding that the government made reasonable good-faith efforts to locate an absent witness, satisfying the Confrontation Clause requirements. In the 11th Circuit, the court reversed and remanded Jane Doe's false imprisonment and sexual assault claims against Carnival Cruise Line, ruling that the district court erred by excluding FBI reports containing an investigator's conclusion of consent. The appellate court found the reports admissible under Federal Rule of Evidence 803 because they were timely and the agent had relevant training.
Indiana Patel affirmed a summary judgment for Telfair County in a civil rights case involving judicial estoppel, finding the plaintiff inconsistent with his prior bankruptcy testimony.
Additionally, the court affirmed summary judgment against Ruth Collins in a False Claims Act case regarding fraudulent PPP loans, holding that the defendant's criminal convictions precluded her from contesting liability in the civil action on an estimated $361,294.74 award. The court dismissed Jonathan Rafael Ortega Martinez's appeal based on his enforceable sentence appeal waiver, noting the 120-month sentence fell within the advisory guidelines range. Moving to the 3rd Circuit, the court affirmed Luis Figueroa's kidnapping and firearm convictions, rejecting his statute of limitations challenge after finding his plea agreement waiver remained enforceable despite a subsequent plea withdrawal. In the 4th Circuit, the court split on Markel Trevon Smith's case by affirming his machine gun possession conviction but reversing the sentence application of a 4-level serial number enhancement under Sentencing Guidelines Section 2122-4BI. The court determined the firearm retained a legible serial number, failing to meet the requirement that original information be rendered illegible. The 4th Circuit also affirmed Paul Anthony Valdez Jr.'s denial of a motion to suppress evidence and Contessa D. Williams' denial of a sentence reduction under Amendment 821. Dennis James DeFranco's appeal was dismissed for mootness after he served his 9-month sentence with no remaining supervised release term. In the 6th Circuit, the court affirmed David Taylor's pretrial detention order, finding by clear and convincing evidence that no conditions could assure community safety given the nature of his forced labor charges carrying 20-year maximums. The 7th Circuit held federal statute unconstitutional as applied to Stephen Anderegg for possessing virtual CSAM in his home, ruling that Stanley v. Georgia protects such possession regardless of interstate commerce implications. Finally, in the 8th Circuit, the court affirmed Bruce Strickland's drug and firearm convictions after he voluntarily withdrew a guilty plea, forfeiting claims regarding the agreement. The court also affirmed Jeremy Jantile Burton's felon in possession conviction, rejecting his argument that excluding expert testimony on drugs violated his right to present a defense. Malaki Goodwin's supervised release was revoked for a 9-month prison term based on his history, and Darius Carter's conviction for conspiring to make false statements to acquire firearms was affirmed despite an evidentiary error regarding irrelevant testimony about a victim's death. Back to you, David.
Thanks, James. Let's turn to Aisha covering civil rights.
Thanks, David. We have 18 cases today across 6 circuits, 4 reversals, 3 vacators, 5 remands, 1 dismissal, and 5 split outcomes or affirmed cases with unusual reasoning. Starting in the 1st Circuit, the court affirmed summary judgment on sex discrimination claims but reversed on retaliation and remanded for a new trial against the New Hampshire Neurospine Institute and Dr. Uri An because the employer's stated reason for firing Gina Russo was pretextual under Title VII. Moving to the 10th Circuit, absolute judicial immunity barred all claims in Marquise Miller's lawsuit against Chief Judge Timothy DeGiusti for conduct during a pending case, resulting in an affirmation of dismissal. In the 11th Circuit, there are 3 major dispositions. The court affirmed summary judgment on retaliation but vacated discrimination findings and remanded Rishi Arora's case because the lower court used the wrong standard for adverse employment actions under Muldrow. It reversed qualified immunity and remanded Jonathan Burton's Eighth Amendment medical care claims against Dr. G. Espino due to genuine disputes over his epilepsy treatment, and it vacated a permanent injunction on Georgia redistricting maps, remanding the Alpha Phi Alpha case because the Supreme Court's new Calais decision requires proof of intentional discrimination rather than just effects under Section 2 of the Voting Rights Act. Over in the Fourth Circuit, the court affirmed summary judgment for officers in Amber Sutton Masingo's Section 1983 complaint, but dismissed Najia Rahmani's appeal entirely for lack of jurisdiction because she tried to appeal a non-final order. The Eighth Circuit reversed qualified immunity on excessive force claims regarding later volleys of gunfire and remanded John Holland's case against the city of Seaxton, while affirming summary judgment for Officer Corey Obregon and Sherry Renee Prunty's seizure claim where no clear law existed at the time. Finally, in the Ninth Circuit, the court affirmed in part and remanded regarding HUD grant conditions in King County v. Turner to narrow anti-discrimination requirements. It affirmed denial of qualified immunity for a mental health professional in TWV Kreckenkamp, who violated a detainee's Eighth Amendment rights, and it reversed qualified immunity denials for deputies Gross and Keeling while granting it for Deputy Maxwell and Rayford regarding evidence fabrication and Brady claims, noting the report was not admitted at trial. Back to you, David.
Thanks, Aisha. Let's turn to Michael covering constitutional law and habeas petitions.
Thanks, David. In this block, Michael Reeves covers 7 cases from the 10th and 4th Circuits involving habeas corpus and prisoner litigation. The disposition roll-up shows 1 affirmation, 4 dismissals, 1 denial of a certificate of appealability, and 1 dismissal of a mandamus petition. Moving to the 10th Circuit, Jason Martinez's request for a certificate of appealability to appeal his Section 2254 habeas petition was denied because he failed to make a substantial showing that jurists of reason would find it debatable whether the district court's procedural rulings were correct. The court applied the firm waiver rule, finding his objections to the magistrate judge's report untimely. Over in the 4th Circuit, Brandon Jowan Mangum and Omel McLean both had their appeals from Section 2255 motions dismissed after failing to demonstrate that reasonable jurists could find their constitutional claims debatable or wrong. Benjamin Ariel Felix saw his challenge to sentence execution affirmed as the court found no reversible error, while noting his appeal regarding a Fed. R. Civ. P59 motion was improper due to a failure to file an amended notice of appeal. Ray Edward Chestnut's petition for a writ of mandamus to compel a ruling on his habeas petition was denied as moot since the district court had already dismissed the underlying case. Finally, David Kelly and Jeffrey Tucker both had their Section 2254 appeals dismissed for failing to show that the dispositive procedural rulings or the underlying claims were debatable under the standard set forth in Gonzalez v. Thaler and Slack v. McDaniel. Back to you, David.
Thanks, Michael. Maria has the business and civil updates.
Thanks, David. Today's business and civil docket features 12 cases across 4 circuits. The disposition roll-up shows 1 vacatur and remand, 2 dismissals, 1 denial, and 8 affirmances. Starting with the 10th Circuit, Martinez-Viguerias v. Blanche was a significant win for the petitioner. The court granted the petition for review, vacated the Board of Immigration Appeals decision, and remanded the case. The panel held that the agency misapplied the clear error standard when it reversed 3 specific factual findings regarding the petitioner's eligibility for deferral of removal under the Convention Against Torture. Moving to the 11th Circuit, we see Frederick Silver v. National Credit Systems dismissed as untimely because a successive motion containing identical facts did not reset the 30-day appeal clock. In contrast, David and Jennifer Foley v. Orange County was affirmed regarding an award of $115,131.50 in attorney's fees. The court rejected arguments that the district court abused its discretion or usurped the plaintiff's claims. Also in the 11th Circuit, DeAndre Arnold v. the City of Hampton was affirmed on dismissal and related procedural motions, with the panel finding no exceptional circumstances to warrant counsel appointment. Jeremy Ellis v. Hillsborough County Sheriff's Office also resulted in an affirmance for the plaintiff. The court held that the jury instruction barring termination for false statements made within an EEOC charge remains binding precedent and sufficient evidence supported a but-for-causation finding. Over in the 3rd Circuit, Timofey Vino Dialogue v. the United States was affirmed regarding the denial of a motion to return the domain name warrenfakes.com. The court ruled that the appellants were not lawfully entitled to possession because their affiliated entity was designated as a blocked person under federal sanctions. Turning to the 4th Circuit, Julie Garrett v. Kathy Campbell was affirmed on summary judgment in a bankruptcy adversary proceeding, while Peter Gakuba v. Baltimore officials and Sherry Phillips v. Pitt County Memorial Hospital were both dismissed for failure to state a claim and improper venue, respectively. Amberly Williams' petition for a writ of mandamus was denied as the record showed no undue delay by the district court, and Najia Rahmani v. Stanley Dole was dismissed for lack of subject matter jurisdiction over a non-final order. Finally, Najia Rahmani v. Stanley Dole was dismissed for lack of subject matter jurisdiction over a non-final order. And Sherrod Brown versus the Federal Communications Commission resulted in a grant of review where the court set aside the FCC's Media Bureau public notice. The panel held that extending lowest unit charge rates to political parties with non-candidate members contravened the plain language of federal statute. Back to you, David.
Thanks, Maria. Now let's turn to Raj covering immigration and government law.
Thanks, David. In this block of 13 substantive immigration and government cases, the courts dismissed 4 petitions, denied 5 petitions, affirmed 2 rulings, vacated 1 panel opinion for en banc rehearing, and vacated and remanded another case on standing grounds. Leading with the movements, the 11th Circuit vacated its own prior panel opinion, enshrined A. Jones-Carter-Gilliam against the United States and Tennessee Valley Authority to grant a full court rehearing after a majority of active judges voted for it. In the 9th Circuit, Oceana Incorporated's challenge to the National Marine Fisheries Service was vacated and remanded because the group failed to demonstrate that its members' injuries were traceable to the agency's rule changes, or that the requested relief would fix those harms. Moving to the 1st Circuit, the court dismissed Duke St. Vaughan Keith Bromfield's petition for review regarding adjustment of status and asylum, holding it lacks jurisdiction over discretionary decisions by the Attorney General under Section 1182I Ag and Section 1255, as well as determinations on whether changed circumstances excuse the 1-year filing deadline. In the 3rd Circuit, Jose Ramiro Mejia Henriquez's petition was dismissed as moot after he was removed to El Salvador and is now incarcerated there, meaning any relief on his Convention Against Torture claim could not redress the underlying removal order or statutory reentry bar. The 4th Circuit denied 3 petitions in a row. First, it denied Dora L. Adkins' mandamus petition seeking to compel a district court to rule on emergency motions, finding no undue delay and that mandamus is not a substitute for appeal. Second, it denied Sheriff Phillips' request to stay monetary sanctions for repetitive litigation in an employment dispute, upholding the lower court's ruling under the strict standard for extraordinary circumstances. Third, it denied Sajjad ul-Hassan's petition for review of asylum and Convention Against Torture denials, finding substantial evidence supported the agency's conclusion that there was no nexus between his claimed social group and the threats he faced. Finally, in the District of Columbia Circuit, the court affirmed Norwich Pharmaceuticals' retention of 180-day marketing exclusivity under the failure to market provision but reversed regarding the failure to obtain tentative approval due to an incorrect legal standard applied by the Food and Drug Administration. The court also affirmed the National Marine Fisheries Service's annual catch limits for South Atlantic red snapper based on landings rather than total catch, rejecting arguments that subsequent rule changes made the case moot. In a separate environmental matter, the court denied a challenge to the Environmental Protection Agency's retention of air quality standards for nitrogen oxides and particulate matter, ruling the agency did not violate the Endangered Species Act by finding no effect on protected species. Lastly, the court denied petitions challenging the Federal Energy Regulatory Commission's authorization of a liquefied natural gas export terminal in Louisiana, holding that the burden rests on challengers to prove the project is inconsistent with the public interest under the Natural Gas Act. Back to you, David.
That wraps up today's broadcast of Do It for the Case Law for Tuesday, August 25th, 2026. A huge thank you to our reporters James Taylor with 18 cases, Aisha Johnson with 18 cases, Michael Reeves with 7 cases, Mariah Santos with 12 cases, and Raj Patel with 13 cases. Today's docket featured significant shifts in the law, including reversals, vacated decisions, and remands that will impact future litigation. Several appeals were dismissed on procedural grounds or for other reasons. Visit doitforthecaselaw.com to listen to more in-depth per-case reporting. Do It for the Case Law is a news reporting service. We summarize and discuss published federal appellate opinions. Nothing in this broadcast constitutes legal advice. We are not lawyers. If you need legal counsel, consult a licensed attorney in your jurisdiction. Subscribe and follow us for tomorrow's briefing.